Today's courtroom session begins with a major shift, a first-degree felony case carrying a punishment range of 5 to 99 years. And right from the opening seconds, you'll notice how quickly the tone changes as the judge questions defense counsel, clarifies the seriousness of the charge, and takes control of the room. This is a moment where legal strategy meets reality. Attorneys adjusting roles, the state confirming offers, and the court setting deadlines that will shape the future of the defendant. Stay locked in, because what starts as a simple scheduling discussion escalates into a life-altering plea, a debate over no-contact conditions, and finally, a 12-year sentence with strict restrictions. Watch closely. Every detail matters.
Here on John Castro Lopez.
Morning, Your Honor.
Good morning. Where's your client?
He's in custody. He's right there.
He needs to come down.
Too many things on my left, sorry.
No, I mean, the defendant needs to come down too.
Of course.
All right, so an offer is due today.
Yes, Your Honor.
And did you tender an offer?
I have.
All right, sir, how old are you?
28.
All right. Norma, set this for a plea deadline date in 2 weeks, please.
Honor,
Yes.
I wanted to raise something before we set a date. This is a first-degree felony,
Yes.
and based on last week, you appointed someone else on the first degree and myself as second chair.
Yes.
It seemed like that might be an appropriate thing to do in this case. And I'm just suggesting that. And I wanted to see if you would be willing to appoint Mr. Leal as first chair and myself as second, because this is a first degree felony. I thought it was actually a third when I got it. And Mr. Spear is...
Here, things shift in a way many viewers might miss. The defense suddenly realizes this isn't a lesser charge. It's a first-degree felony. That difference is massive in the legal world. First degree means extremely high sentencing exposure, strict legal standards, and mandatory appointment of a more experienced attorney if the court finds it appropriate. When defense counsel asks to bring in a first-chair lawyer, it signals how serious and complex the case actually is. Judges take proper representation very seriously, especially on severe charges like this. What do you think? Was the attorney right to request stronger counsel at this moment, or should he have continued as led? Tell us your thoughts.
And Mr. Spear has indicated that it is first degree, so.
Okay, so are you on the first degree, Will?
No.
All right, so then we'll need an attorney appointed for first degree.
And Mr. Leal is an attorney for first degree.
All right, so Norma?
Yes.
Mr. Leal is to be placed as first chair on this case, and then set this for a plea deadline date in 3 weeks. And co-counsel will tell you what's been going on.
And Your Honor,
Yes.
on the offer, I may have misunderstood, but my understanding was that the state was still considering the offer.
Well, Judge, I have an approved offer, but there is something that when it was discussed with the district attorney, I think his understanding of it might be different than what it actually is. So I'm just going to go back and seek clarification. So the offer I've extended an offer, the offer may change.
All right, so your plea deadline date is in 3 weeks. What date? All right, August 18th.
Thank you.
All right, once you sign the reset form, you're excused, and I need an acknowledgement of discovery signed before you leave. All right, thank you. No problem. John Castro Lopez.
Judge, I do have a victim impact statement to read after this one.
Sure.
We can just do it right here, if that's okay.
Court is calling 2025 CR 0055792. State versus John Castro Lopez. Can I have parties announced for the record?
Jeffrey Wright for the state.
Rafael Leal for Mr. Lopez.
And are you Mr. Lopez?
Yes, Your Honor.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, sir.
All right, and the court will note for the record that the court previously received an acknowledgement of discovery on July 28th, 2025. There's been no new discovery since that date. Is that correct?
Correct, Judge.
All right. Mr. Lopez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel,
Right
do you
here,
waive
we
the...
enter one of the most critical phases of any felony case. The plea admonishments. The judge confirms that the defendant has reviewed every document, understands every right he is giving up, and acknowledges the punishment range, which, for this charge, goes all the way up to life imprisonment. This ensures the plea is voluntary and informed. Notice how methodically the judge covers each detail. Rights to trial, confrontation, silence, immigration consequences, and the ability to withdraw the plea if the court rejects the agreement. This isn't just formality. It protects the integrity of the case and ensures the defendant cannot later argue he didn't understand. In situations this serious, clarity is everything.
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
State moves to proceed on count 1 and waive count 2.
Any objection?
No objection.
All right, off the record. Deputy Laura, could you have them moved? Yeah. Could you have them not talk so loud? It sounded like it was in stereo coming from this end. All right, we're back on the record. Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, your charge is possession of child pornography younger than 10 years of age. As a first-degree felony, the range of punishment is 5 to 99 years or life and up to life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
It does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, Judge.
Mr. Lopez, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, you will be deported and not allowed re-entry and denied naturalization. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 12 years in the prison. There are no applications. There's to be Chapter 62 compliance, and there are no contact with, that to be the plea. Defense?
Yes, sir.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? You're gonna have to speak up so she can hear.
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers State's Exhibit 1 and attachments.
No, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. That there is sufficient evidence to find you guilty. All right, so why should I follow this plea?
Well, Judge, my client has taken responsibility. He's fully admitted to his actions. Did not play games with the district attorney or the court. I think he's doing that right now, as opposed to dragging this out and making the witnesses and the other people involved to be in court and present testimony. I think it is an appropriate sentence given the circumstances, and also my client has not other convictions, no meaningful criminal record of any kind, Judge.
All right. And then this no contact order that's outside your agreement. That's his child?
Yes, Your Honor.
All right, but isn't there according to this, on this page,
The child went through a forensic interview and did not provide any.
but there's the photo of his child, so that would be a no.
Okay.
This next section is especially important and emotionally heavy. The judge raises concerns about a no-contact condition involving the defendant's own child. The defense points out a forensic interview where no direct disclosure was made, but the state notes that the evidence includes a photo involving the child. This creates a difficult legal and ethical situation. Even when a plea agreement is reached, judges can impose conditions they believe are necessary for safety. When the judge says, "This can be a deal breaker or you can go to trial," it shows the court will not compromise on protective measures for minors. The defense ultimately chooses to proceed. What would you have done in this moment except the condition or risk trial with a first-degree felony?
Okay.
And if that's the deal breaker for anybody, then you can always go to jury trial. But
I explained that, to my client, George, and we're willing to proceed.
all right, the court is going to sentence you to 12 years in the prison, give you credit for any time served. Chapter 62 compliance. There's to be no residing in households with minors, no contact with minors. There's to be no contact with anything else with regards to sentencing.
I don't know if I missed it, Judge, but this is a 42A.054 offense. Because it occurred after September 1st, 2023.
Yes.
Okay.
Is there anything else?
Not from the defense.
All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. You said there's victim impact?
Yes, Judge, I'll just be reading it off.
Okay.
And that brings this case to a close. The defendant received a 12-year prison sentence, Chapter 62 sex offender registration requirements, and strict no-contact restrictions involving minors. Because this was a plea agreement and the court followed it, the defendant waived his right to appeal, meaning the sentence stands as final. This hearing gives us a clear look into how serious first-degree felonies are handled, how courts ensure defendants understand every consequence, and how victim protection always remains at the forefront. If you found this breakdown helpful and eye-opening, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more in-depth courtroom analysis.